Looks like we're live. So I will get started. This is the Common Council Ordinance Committee regular meeting, June 15th, 2021. I'm going to start over because it looks like I pre-opted the YouTube. Today is June 15th. It's the Common Council Ordinance Committee regular meeting. It's 7:02, and I'm going to take the roll. David Hoovelman.
Present.
Dominique Johnson.
Present.
Tom Keegan.
Here.
Don Livingston.
Here.
Manny Langella.
Here.
Dean Roberts.
Present.
And I'm Lisa Shanahan, the chair, and also present. We have all of our committee members here. Our first order of business this evening is a public hearing on Chapter 59A, Housing Equal Opportunity, Section 59A-1 and Section 59A-2. Do we have anybody here to speak on that?
We do have one person from the public. I don't know if she would like to speak on it. If you'd like to, Diane, please raise your hand. No, I don't see anyone with their hand raised. Okay,
so I will close the public hearing then on Chapter 59A, Housing Equal Opportunity, Section 59A-1, Section 59A-2. The second matter that we have for public hearing this evening is Chapter 60, Human Relations Commission, Section 60-1, Section 60-2, and Section 60-5. And once again, I'm calling for anybody who'd like to speak this evening on those three sections.
There's just one person on and no one's raised their hand.
Okay, so good. So I'll also close the public hearing on those two sections. So at this time, we should be moving forward, and the question, I'm calling for a motion to send these two sections on to the Common Council for adoption. Is there a motion to send? I guess we should do one at a time. We'll do 59A, Housing Equal Opportunity. I saw Mr. Livingston's hand up.
Yeah, I move it, but I do have comments.
Yeah, I have one or two comments as well. Great, thank you. Why don't you go with your comments on 59A?
Okay. This gets back to, well, there's one suggestion and a couple conforming comments. And the conforming part goes to all, the suggestion goes to all of this. So I just find it very difficult to read, but that's not what I'm not gonna make a major change. But in the first parenthetical, where it says define as heterosexuality, homosexual, etc., or asexuality, whether actual or perceived, I think that what we mean is the actual or perceived apply to any of those ideas of sexual orientation. So I think it should read in each case, whether actual or perceived. So that's first suggestion, because I think that's what we mean. And then the others are these same conforming changes I've been trying to get. So and they're small, and I have them for each of this, but on the 5th line, before on the right-hand side, before the word blindness, there should be a comma, included but not limited to, comma, blindness. And then in the next line, it says deafness, and insert the words and, so it's and or status as a veteran. And that's what we have in the other ones.
Yeah, I had that same comment with the and or.
Okay, and then you go to 59A2, and I would add the words in each case, again, before whether actual or perceived, and then when you get to status as a veteran, add in the words and -or. Those are my suggestions.
I agree with those two suggestions. Does anybody else have further comments on those? So the motion's on the table to move Chapter 59A-1 to Common Council, and we want to make the motion to be amended to pick up the changes of Mr. Livingston. So with those two changes, should we take a vote? I think we can do it by hand vote. All in favor? All, that's unanimous. So 59, Chapter 59A, Housing Equal Opportunity, Section 59A-1 and 59A-2 is moved to Common Council for a vote at that place. The next one we're voting on is Chapter 60, Human Relations Commission. We have three sections, 60-1, 60-2, and 60-5. And once again, we're voting to send this on to Common Council for vote. So do I have a motion to send it to Common Council? Dominique. Mr. Livingston, you probably have similar comments
I do.
on the and/or part for sure.
Well, I have, okay, let's
And
start
what?
with 60-1 before the words whether actual or perceived, insert in each, the words in each case. But in 60-2, we need to add the words in each case in the parenthetical and also the words and slash or before status as a veteran.
Great. That's terrific. And Brian, you have all of those comments for us, right? Great.
All those comments are now in pending vote.
Okay, great. And Dominique, it looks as though you have a question or comment.
I just want to be sure we reconciled the use of past or present or past, but make it uniform. So Tom, I'll defer to you, but.
Well, you know, Dominique, I saw that and I decided since they're both in section 60 versus and treated one way in section 60 and the other in 59, I don't think it makes a big difference. We could change
Okay.
them.
Okay.
Obviously, if the meaning's the same, and since it's the same section, I figured to leave it. But if others
Okay.
feel differently,
No, that makes sense to me as long as the meaning's intact and that's what matters. So,
yeah.
okay, I'm with you. That's good. Yeah.
Great. So now call the vote on the motion, which is to move section 60, Human Rights Commission, section 60-1, 60-2, and 65 to Common Council for a vote. So the motion's on the table. All in favor? We have a unanimous vote. So we'll move both of those sections on. Thank you very much.
Thank you.
The next item on our agenda is a public hearing discussion. So again, I guess we'll defer to Larry or to Brian as if to find out if there's any comments, public comments that need to be read into the record or anyone who would like to speak tonight.
Yeah, yes, we do have Diane Larachella. Diane, you can unmute.
Good evening, everyone. I hope you're having a good ending of spring and early summer. I'm sorry that there aren't more people checking out your continuing good work. I first just wanted to say, just in general, I'm very happy that changes were made in chapters 59 and 60, but I just didn't feel a need to speak to them particularly, but thank you for those changes, and I think it's a great idea. I'm here tonight just to briefly speak on a matter under discussion, and that has to do with the possibility of merging the Planning and Zoning Commissions. Right now, I'm leaning very much against such a combination, and I'll tell you why. I think that in all the 30 plus years that I've been in Norwalk, and I did witness the splitting of the commission. I think some of the reasons why this is being considered, and I'm not against a consideration of it. I just feel that before any decisions are made, the following needs to be reviewed. Number one, I hope that we will be having public hearings on this particular important step in governance before any vote is taken or any changes made, because I think maybe because we're beginning the summer, the public, I know a lot of the public that participates in certain important zoning applications would be very interested in this. Number two, I want to make sure that before decisions are made, that this fine group in the Ordinance Committee takes a look to see what other cities have. I know smaller towns like Westport have a combined Planning and Zoning Commission, and also many of these combined Planning and Zoning Commissions are elected positions, which would require a charter change. I know that is not currently on the table, but I wanted to know, because of the volume of work being done, whether it makes sense for these volunteers on the Zoning Commission to take on even more work. And some have mentioned that the Planning Commission really doesn't do much. Well, I'll tell you this, if we were to truly seize upon what the charter says the Planning Commission is supposed to do, and because we now have the reorganization of Jessica in the mix and others in new redevelopment agency, I would like to see them do more as far as true planning and not just react to things that they have in the charter, like the capital budget and taking a look at subdivisions. I'd like to see them truly look at holistic, comprehensive planning for our city. And that would include, as many of you would not be surprised, better climate change planning, because there's very little being done by any entity in this city right now. In the methods that I see Bridgeport and many other cities that I have friends that are actually in those positions, in sustainability positions, in Middletown, in Bridgeport, etc. Lastly, in your section in chapter 79B, I guess it is, in the search committee, whether or not you combine, I'm currently leaning against in any way combining these two commissions, because I think the amount of work that I see the zoning commission doing, especially right now that they're in the midst, or actually just the beginning of zoning changes. And I'm very pleased that Mr. Kleppen and Mr. Schulman are on this Zoom call. I think that is a well-needed, long-needed, and they're going to be at this for many, many months. I think that it's inopportune to even consider a combination at this time when they have all this work to do. I think that section B, 79B, under search committee, since you are making some changes, I just wanted to throw this out on your table. And that is, I wish in the selection committee for a future planning and zoning director that you would add citizen representatives so that it's not so insular with people that I think that you need either neighborhoods, maybe a select group of neighborhoods like West Norwalk Association, Silvermine, and ENNA, have some citizen representatives on your search committee at some level of that search. So that way you get a sense as to whether the public is included in when things are done on a daily basis. With that, of course, diversity is very important too. So I would love to see wording under search committee that we look at diversity. So with that, I thank you. I wanted to say that this, if true planning had been taking place in the holistic way that did not happen with Steve's predecessor, and I sat through many committee meetings. I don't think most of you on this Zoom call, other than maybe Mr. Schulman, have ever sat through a lot of the discussions of the Zoning Commission and the Planning Commission. We cannot be just a reactive. These commissions are very important. They must be proactive and take over more of the work. In fact, we had a discussion until recently that the Zoning Commission and or the Planning Commission would take over more of the work that we had assigned or we had just let the redevelopment agency do. And a lot of us felt that the redevelopment agency wasn't necessarily always listening to what we need in our city. So before we look at combining these two commissions, are we currently utilizing them and managing them in a way that optimizes their usefulness in the charter? Thank you very much and have a good evening.
Thank you, Diane. All right, so the next item on our agenda is the acceptance of the minutes. And just for the record, we've decided that we're going to put off the acceptance of the minutes of May 18th, 2021, as there's going to be some adjustments to those minutes to make them more reflective of the conversation. So the next item of business is old business, discuss and vote Chapter 38, Article 2, fireworks and firecrackers. And we're looking at sections 38.7 through 38.13. And I see that Broderick has joined us. So that's terrific.
Lisa,
Yes.
do we have to have a vote in order to pass the minutes?
We're not, do we have to have a vote on passing minutes?
To postpone them for another?
Yeah, sorry.
Yeah.
Tom, do you want to make that motion? You have your hand up.
Yeah.
Sorry.
I was about to say that. Yeah.
No, just,
A
I mean,
motion is on the table to
Defer,
pass on the acceptance
I
of
would
the
say,
minutes.
yeah, defer consideration of the minutes until the July meeting.
So that's the motion that's on the table. All in favor? Anybody opposed? No one's opposed. That passes unanimously. Thank you, Brian. I probably did jump
it's
right over that.
it's just for the record.
Yeah, thank you for making sure that my record's clean. Back to chapter 38, Article 2, sections 38.7 through 38.13. And what we're basically looking at here is the fireworks. And I have to thank Mr. Livingston because he did come in and make some really pretty significant and important changes throughout the entire section. And I just have two questions for Broderick. My first question for Broderick is, it's under section 38.8, license for exhibitions. There's a reference to this, and Mr. Hoverman kind of highlighted this too. It says each said license shall issue for exhibition purposes only, and only to one skilled in the discharging of fireworks. And I don't really know what it means to be skilled in the discharging of fireworks. Is that a term of art? Should we eliminate that and just say someone who's licensed? Can you give us some clarity about whether that's a useful phrase?
That's directly in the Connecticut General Statutes. There's a section there in regard to license, and that's done by the state. So I don't think you need to do anything with that because we can point directly to let me turn this phone off, sorry. We can point directly to that statute.
So we think that there might be case law that explains what skilled in this discharging of fireworks is then.
Yeah, that's at the state. I can try to find out what their requirements are and get it back to you. But generally, that's all up to them with the licensing.
So it's a term of art. And David, you have your
Madam
hand
Chair, should we not then just add and only to one skilled in the discharging of fireworks as prescribed in the Connecticut General Statutes where we have the same reference, since we were referencing statutory requirement?
Do you have a thought about that? You've got your hand up.
Yeah, I don't know that we can, in the sense that I don't believe it's defined in the statutes as you just said, Lisa. I think it's going to be case law. So maybe there's words we can come up with, but I don't think we can just say, we can't say as defined in the statutes unless Broderick knows where there's a definition. So that's the problem.
So as long as it's, we're referencing language that's been elsewhere, I find it so vague and not really sure how one would.
If that does come up as the AHJ, I would make a final determination, as to how they're licensed. And generally, you have 3 or 4 shooters that are always in our town. We always check their license when they apply. I haven't seen any problems with it, and I think we can definitely get around that glitch.
The phrase itself seems strange to me, so I wanted to understand it better why it's used. And Mr. Keegan, you have your hand up.
Yeah, I would expect that if the state of Connecticut issued anyone a license to set off fireworks, that they'd know what they're doing.
Just so everyone's aware, I think it's General Statutes 29-364. It's licenses, denial, suspension, or revocation. It's the second sentence, I believe. It's at least the second line. I believe it's the second sentence. All licenses shall be issued upon receipt of the application, therefore, upon license forms provided by the Commissioner of Emergency Services and Public Protection, which forms shall include such information as said Commissioner requires. And then it talks about all licenses being issued under the provisions of this section shall be used only by the person, firm, or the corporation to whom they are issued, and they should not be transferable. So there might be some more information as to what the requirements are from these state departments, but there is a statute that specifically identifies that if you apply or for said license, you can't hand it over to somebody else and let them use it. And there is an application that needs to be filled out. So there's obviously going to have to be some standards that someone would have to meet in order to.
It's pretty difficult process.
Okay, so good. So we can feel comfortable about that. And then I just had one other question to Tom, because you were so wonderful about doing the first cut on this. So in section 38-7A, and then it's large B again. In one section, we just refer to the Office of Fire Code schedules of fees. And then later in the same section under D, we then lay out 2 of the fines, the $200 per day. Is that what we want to do, or do we want to just refer to, do we want to refer to a schedule, or do we want to let everybody know that we're upping the fines? And I'm good with either approach. You see what I'm doing, Tom, under D?
Yeah, I'm trying to look at my screen.
Mhm.
All right, so under D, it says,
Under D1 and 2, we actually we name the fees, but prior to that, we just referred to a schedule. And I didn't know if we want to be consistent in that or whether we're really wanting to bring people's attention to the fact that we're raising the fees substantially for not submitting to inspection. And I'd just like to know what the committee thinks about that.
as a general rule, I agree with where you're going, I think, which is to have it subject to a schedule, but I defer to Broderick on this in terms of,
Yes, Tom. I agree. Thank you for all the assistance in doing this. The $200 is also in the statute. So that's-
29-295.
yeah, so that's what they're going to get. Whether, Norwalk says something else, you're going to get the $200 fine.
So just so everyone's aware, 29-295, which is the statute that we rely upon, is a penalty for violation of this specific section of the code. And it says any person who violates any provision of the fire safety code shall be fined not less than $200 or more than $1,000. And then it goes on for imprisonment. But what we put in $200. It can go up to as much as $1,000 for this. So it has to be between 200, no less than 200, no more than 1,000. We put in that number, and I cited specifically to the code at the end, and we crossed it out just so people were aware of where we were getting this from, not that we were going to insert this into the code.
Mhm,
That being
yes.
said, I don't see how it would be problematic to just say that shall be subject to an initial fine as established in the Office of the Fire Marshal's Schedule of Fees or something on those lines. We could certainly do that. And then the Office of the Fire Marshal can rely on the statute and use a penalty fine amount that everyone would be okay with.
I think what I've learned from Mr.
Yes.
Livingston and these is that we like to refer to a schedule so we don't have to, amend the fireworks section every time we decide that the fees are too low. So what do we think? Should we make that one change? Are we comfortable with
Yeah.
that?
yeah, make the change.
Okay. Great. Does anyone else have questions or comments with regard to the firework ordinance? Well, I think we're at the stage right now where we want to take a vote to send this on to public hearing in the month of July. So,
Lisa, real quick, I just want to read it to everybody so they, because I just made the change.
okay.
Actually, I could probably share the screen as well while I do this. I can see if I can do this well. Let's see how I do. Everyone see it? It's top of, it's highlighted. D1 is highlighted here. Penalty for offenses. Any person violating this section shall be subject to the following penalties. Subsection 1, an owner, designee, or legal occupant that fails to complete an inspection in a timely manner as prescribed in Connecticut general statutes and the fire safety code, shall be subject to an initial fine as established in the Office of the Fire Marshal's schedule. And then it indicates that each day that the violation exists shall constitute a separate violation. And we're going to have to change the third section as well, which is highlighted in bold, as you can see. Make it consistent.
Yeah.
Only
so
thing I would, sorry, just add schedule of fees.
Yeah.
That's what we call it below.
I just had a thought. With violations and fines, with housing and most of our occupancies, they'll end up going to court for us to gain compliance. So it's possible it may never get to that $200. It's a very long process. Most of the folks that I've dealt with in my experience here, they comply. It may take them a little bit longer. We offer more time as long as they're working towards compliance. I'm fine with whatever the committee goes with, because I think this is pretty solid.
So leaving it with the schedule of the fees from the fire marshal's office, is that okay with you?
Absolutely.
Mr.
just so
Kagan, you had
everyone's-
your hand raised. Did you have a question or something you wanted to suggest?
Yeah, I was just going to ask the fire marshal, Brad, is this what you were looking for when you first brought this forward to our committee? Is this what you were looking
Yes,
for?
This is much more of a hammer, and I'll use Brian's term, carrot and stick, to gain compliance. This is really, really, I think it's good. I mean, from from what I see in working with you folks.
And just so everyone's aware, for consistency, D1 and D3, D3 has been changed to say following the initial violation, each subsequent day that the violation exists shall be subject to a fine as established in the office of the fire marshal's schedule of,
Schedule of fees and fines, is that what was the language earlier?
well, it says fees before, so we could change it to fees and fines.
No,
Right.
schedules of fees is fine. That's great. That's what you said
You
before.
just switch that over there. And again, just so when we, I'm just going to stop sharing the screen. When we did this a couple years ago with Broderick having to get into multifamily houses, it was because the fire marshals were getting stiffed and ignored, and there was some liability that was could be placed on the city in that regard. And so that was a way, carrot and stick, to get at least some people, the people who maybe weren't aware or wanted to be compliant with Broderick, so that Broderick and the other fire marshals didn't have to go chase them down, and save at least some time and focus on the real people who weren't trying to do the right thing. It's the same thing here. Most of the people who are going to be selling fireworks are going to do the right thing. And by offering this carrot and stick approach, we're basically telling them if you apply if you make the application and you tell Broderick in a timely fashion to come in and take a look at our place so you can inspect it, it's going to assist the fire marshals to not have to chase people down. They'll know the people that have applied, and they have to do these inspections anyway. So it's just a way for people to save on the cost of the inspection, and it helps the fire marshals. It's a similar purpose than for what we had with the other thing, because we don't have enough fire marshals to do all these inspections when people are just ignoring them. So it's a way to try and get people to be a little proactive.
Thank you.
You nailed it. A side note, received a complaint today in regard to a large amount of fireworks somewhere in Norwalk. We're trying to confirm that. I've got my guy going to take a peek tomorrow, and they're from Pennsylvania. A lot of them will be for private yard shows, but some of them will more than likely go to some of these places that we're going to inspect. So what you folks are doing here, it's going to be good.
Great. I'm glad that we're being responsive to the questions that you raised. So thank you for letting us know. Thank you for bringing it to our attention.
Well, you guys are awesome. Really appreciate it.
Great. So at this time, if we're ready, I'd like to have someone bring a motion to bring Chapter 38, Article 2, Sections 38-7 through 38-13 to our to public hearing. Thank you, Mr. Keegan. All in favor? Once again, we have a unanimous vote on that. Okay, our next item is to discuss and vote on Chapter 30, which is Capital Projects Program, and Chapter 79, Planning and Zoning Commissions, as well as the possible merger of the Planning and Zoning Commissions. And I'm going to turn the floor over to Mr. Livingston, who has done the heavy lifting again on this section. So thank you, Tom, for helping us out with this.
Thank you. I'm going to take this a little in a different order, because the capital budgets process sort of is related, and it's done as part of this process, but that's not the focus here, obviously. So if I could share the screen, what I'd like to do is go through the changes that are proposed, and I'll explain what we did and why, and open for comments and discussion. I just want to say in the outset that I do agree with Ms. Loricella. I think we're eager to get public input. So any and all comments are welcome. So anyway, if I can share, let's see if I can do this. I have to find a file, right? How do I, okay.
Is it the document that we have on the agenda?
It's actually not.
Oh, it's not, okay.
So where would
So open the document first, then go back to Zoom and click share, and then select the
Okay.
open document.
All right, it's gonna go. Now I'm gonna go click Zoom, share. And where should it be?
Share screen at the bottom, the green little arrow.
Yeah, okay, I have the document up. Sorry about this. So how do I do it again? Documents on my screen, but how do I share it? Share a screen. doesn't,
Go back to Zoom and click share screen, the green, and you should see, it should pop up any windows that you have open.
it's not doing that.
Tom, do you want to email it to me? I could try to share the screen if you want.
Yeah, I can do that. Just one last try before I do that. It says whiteboard, universal access, Google Chrome, contacts. Okay, let me just send it to you. And then I'll just talk to it.
Yeah, under whiteboard should be all of your screens that you have open. But, or documents.
Well, I'll just send it to you. Yeah. All right, well. Nothing's easy.
I wouldn't know how to begin to do this, so
Okay, Brian,
have Larry give us a seminar.
okay, it's sent. Okay. So we can talk generally. I'll talk about it with what we have and then bring up the comments. So, let me go back to the document from the. Okay, so we're gonna go to 79 and until until Brian gets that up.
It's up,
So-
Tom.
Oh, it is? You're faster than me. Okay, so the first section, creation, it's pretty straightforward. This is the authorizing section of the charter. As I said at the last meeting, the charter was amended in 1970 to permit this to take place. Prior to 1971, because it wasn't immediate, there was a combined commission, or I think it was basically planning, and then in 71 they separated it out to separate planning and zoning by virtue of a charter amendment. So this section here is the provision of the charter that allows that. And what we're basically doing is designating the planning commission that we have and is prescribed by charter to be the planning and zoning commission. So what we're doing is we're taking the existing planning commission and turning it into a planning and zoning commission. That is how the charter works. And let me just throw one caveat into all this. We are still waiting for some, I won't say an opinion of sorts and a review of the document by the law department. So everything here is subject to their sign off. I think most of what I think we're pretty good on this, but we still want to have them review it. And there's a couple sections I'll get to that have specific questions, which I'll highlight. Okay, and by the way, this section 79 is taken in large part from the existing ordinance relating to the zoning commission. So it's modified, but it's based upon the zoning commission language. So then you go to powers and duties, section 2, basically saying the commission, which is of course the combined commission now, has all the powers and duties permitted, granted, and imposed by Connecticut state statutes, together with what's granted to the planning commission under our charter. So basically, that's where the power comes from. It comes from Connecticut state statutes and the city charter. So that's section 2. Section 3, let's go to that if you could. This is where we have our first question. And this is what I've asked the law department to give us a little more guidance on. It gets pretty technical, but because we're going off the charter planning commission, which is what the charter provides, as I said, we need to, it's not clear exactly what the composition of the commission will be in terms of the number of members. I say that because the charter provides for a planning commission with the mayor and I think the Public Works head as the tiebreakers. That doesn't work under Connecticut law anymore. So we've asked the law department for an opinion as to the number of members. Currently, and Steve or Lou can jump in at any point. Currently, the zoning commission has 7 regular members and 3 alternates. The planning commission has 10 members. What we're thinking, and you see the numbers here and highlighted, 7 and 5 and 3, I'll get to those other ones, is we probably will end up with 10. And I think, Steve, your latest recommendation was 9 and 1. Is that correct? 9 regular, 1 alternate?
Or 9 and 3, however you wanted. And I think planning is 8 members.
Oh, it is 8. Okay. So we don't know what this number will be. I mean, it's going to be nice to have an odd number. We can work our way around it if we don't, but that's the first question, is how big we want to be. And, you know, I kind of defer to Steve and Lou. I don't know if you have an opinion on this.
My preference is for as small a group as possible. We want it to be manageable. We don't want meetings to be lengthier than they need to be because there are too many members. But I think that the numbers that you're suggesting are quite reasonable. Either one of the alternatives that Steve has mentioned appear to be fine.
So moving forward, I'd like to propose the 9 and 3 then that Steve's recommended, but subject to what the law department says. Anybody can jump in anytime. And we'll come back to this stuff. And then the next provision here provides that no more than 5 be members of any one political party. That's essentially half the commission, right? And that's the standard stuff. The next part says that no more than, what you were sent says no more than 2 regular members shall be from any one council district. We've changed that, or suggesting changing that to 3 to give a little more flexibility in the case of, well, 2 reasons. One, because it's often hard to find people. And the other one is you can have situations where people are resign or filling in vacancies, and it gives a little more flexibility in terms of appointing people. So that's why that's 3. Moving down, the language you see in the next paragraph is all from the current ordinance, with the exception of this thing I've highlighted here. In no instance shall members serve more than 5 consecutive terms as a regular member. Currently, it's 3 terms. That's 3 2-year terms. There are 2 things to note here. One, if and when we set this up, it will be a brand new commission. So we'll be all starting from 0, from scratch, but with a caveat that it's staggered. But we also are concerned that zoning is a very specialized area, and it seems counterproductive, if you will, to force people out after only 6 years, which is what we currently do. So the proposal here is 5, but a similar argument can be made that there should be no term limit, and that we should rely on whoever the then mayor is to fill the vacancy with the person they choose. It may be a reappointment, it may not be. So that's a question for the committee to think about. I personally, I don't feel strongly about this. Again, to Lou and Steve, I think 3 is definitely too short. But whether it's 5 or none, I'm open.
There's something else that I think we talked about it at the last meeting that you should be aware of, and that is that the requirements for currently for the Planning Commission are different from the requirements for the Zoning Commission. There are no term limits right now for the Planning Commission. There are no requirements for political breakdown or for district control in the current definitions for the Planning Commission. I have no opinion on that. I just think that you ought to be aware of that. These other regulations that Tom is referring to here, in at least some form, do apply to the current zoning commission.
Mr. Showman, how long do you feel as though a new commissioner takes to get ramped up to be an effective commission member?
I think it depends on the background of the person coming on the commission, but it takes a good, I think, 6 months to a year to fully familiarize yourself. There's some really specialized things that we have to be aware of that not every other city commission needs to be aware of. In terms of where we gather information from, we can't just go out into the community and ask the community. Theoretically, all of the commissioners are supposed to gain information at the same time, which pretty much means at our meetings. So if there's a community meeting on a subject, by and large, we try to avoid them. And there are other rules and regulations established by the state regarding conflicts of interest and other issues that we have to adhere to. And it simply takes some time to familiarize yourself with those. Steve has been quite good about arranging for training for all of us. But there's, at the moment, there's limited pre-training for someone who's coming on to the commission.
Thank you.
Okay, let's move on, and we'll come back to that before we take any action. The alternate members is just 3, and that's pretty straightforward. Just 3, 2, no more than 2 of any one party. And I think that's what it says now, so nothing new there. Moving down to section 5, what that does is, and again, this is out of a current ordinance, it basically, we're going to stagger the terms. So we're going to have somebody appointed for 1 year, 2 years, 3 years, as you do in any new commission, so that we ultimately only have 3 members, if in the case of a 9-member commission, leaving in any 1 year, because you want to keep you want to minimize the change of personnel, so we stagger them, and that's what this does, and that's what we've done in the past. So that's straightforward. Organization and administration is similar, again, almost identical, I think, what we have. The first section basically gives the authority commission to organize and maintain records and budgets and all these other things permitted under Connecticut law and the city charter. Section B says as a director of planning and zoning appointed by the commission based on the recommendation of the committee, search committee. Lou, I didn't come back to you on this about who should be, how this committee should be set up. I think we said chair and vice chair, but I want to confirm that works. You think that makes sense?
I think it does make sense. When Steve was hired, of course, because we have 2 commissions, it was the chair of the zoning commission and the chair of the planning commission.
Yeah, and we also added the chief of economic and community development, because under our current structure, planning and zoning falls under that department. So that's why that's added. All right. And the rest of the stuff here is right out of the current ordinance. It followed the personnel rules, and going down to 7, anything that's been current regs, which are in effect prior to the effective date, are in full force afterwards. We don't want to lose anything in the transition. So that's just a sort of a saving clause in a way. The next provision is pretty important, the effective date. And so as we were talking about this, we know there's a lot that has to be done. And most specifically, the new commission would have to be made up. And we don't want to rush that. We want to make sure we get the right people. And we don't want to have it influenced by politics to the extent possible. And by that, I mean, We like to get it away from an election season. It should be, keep it just as far away from that as possible. I'm not going to deny politics involved in this, but I think this shouldn't be. And so let's take away that issue. It gives us all time to work through any remaining issues and be effective January 1. So that's the idea there.
I have a practical concern about this. I certainly understand why you're proposing this, and it makes eminent good sense. However, both the zoning commission and the planning commission right now are down in terms of our numbers. And if this isn't going to occur until January 1st, we need some appointees, which may be problematic. It may be even more difficult to attract people if they know that as of January 1st, they may no longer be members of the commission. So again, just to bring that to your attention, we're down a couple of people as of the election. If one of our members is elected to the council, we lose him. And as early as this July, we're losing another member who would have served the full 6-year term. So our problem is actually fairly severe.
Yeah, I'm sorry, I don't want to cut you off.
No, that's it. I don't want to speak for the planning commission, but I know that their chair has a concern about this issue as well.
Yeah, and we have spoken with the mayor about this. It's clearly an issue in making sure we don't have vacancies, that the commissions can both continue to operate. Practically speaking, this won't get done, can't get done before the terms of some of the members expire in July, Rod's term. So, I think we're just going to have a vacancy no matter what we do. And so I think we're going to have to address that. If you think it makes sense to have it sooner than January 1st, I'm all ears.
Well, I think then you run into the political issue you're talking about. Yeah. If it's before the new mayor taking office.
Right. All right. Are there any questions on this section before I go to chapter 30?
Yeah. I'm sorry. Go ahead, Tom Keegan. You had your hand up first.
No, it's okay, David. Go ahead.
Just a question about the balance 9 going from 7 to 9. Should the no more than number of members of one party go up by 1 or 2 from a balance standpoint? So you have right now you have 7, 5 of whom can only be from one party. Should you go 9? Do you go 6 of whom can only be from one party?
No, actually, that's my mistake. It's 9. It's 5 based on a 9, half, essentially.
Oh, it's 5. It should be 5 based on 9. Okay.
Yeah, well, that's my thinking. But that that's not carved in stone. But it seemed to me that's roughly half, because that's sort of the way we operate. And there may be statutes on that, Brian. I don't know how that has to work.
Tom, what are we? What's the total number? You said 9.
9, yeah.
So under the minority representation rule, just so everyone's aware, which is 9-167 9-167A, minority representation requirement. If you have a 9 board, the maximum you can have from the same party is 6, meaning you can have less, but you can't have more than 2. It would be 6 would be the maximum from any one party, but you could certainly have less than that.
So should we, David, are you proposing we put 6 in then?
I'm proposing to put 6 in there.
I'm okay.
I agree with David on that as well.
Okay. Anything else before I move on? Mr. Keegan had a comment or question?
Yeah, I just had a question. Under staff, it looks as if the director of personnel is on the commission. Why would that?
He's on the search committee.
Oh, okay. All right. I'm sorry.
Yeah, if it's not clear, we can clarify, but that's the way it should read. That's basically the way it did read with it. Yeah.
Tom, except that if it's the assistant director of planning and zoning, then director of planning zoning replaces personnel director.
Right.
Okay.
Okay, yeah, I get it. Thank you.
Okay, so Brian, if you can put up,
I just had one more question, Tom, and this is also for Mr. Schulman as well. The idea of when this enacts, is there a way to allow some of the duties to overlap as the new commission is being formed? Can there be a provision for that, or is that just getting too messy? Is that?
well, I think, I don't want to speak for the mayor, but I think our belief generally as a talking group or working group was that it's not going to be 9 new members. I mean, it's going to be people from the existing zoning commission and people from the planning commission. So I don't know if that answers your question or addresses your concern, but it's maybe I don't understand it.
Well, I guess the question is that if we're looking at potential vacancies right now and there's still work that needs to be done while we're waiting for the new commission to take effect, can the new commission have any weight and authority prior to January 1st, 2022?
Not the way this is set up. No, it doesn't come into existence until that date.
I think one thing we could do, I mean, it's probably going to be more so an issue with the zoning commission than it would be planning based on just the types of applications, the volume and the complexity that they receive. I think if you get down to December and there's a concern about having an application roll over into a new commission, I would think the zoning commission could always hold a special meeting or meetings in December to try to wrap up any outstanding applications. And on the staff level, I think we would convey to all applicants in the queue that, it's in your best interest to try to get these done, before December 31st. And that way, or start new as of January 1 when the new commission is in effect.
Okay.
I think that would serve. I know that in the last meeting, we talked about workload and then we don't want to overload. So I'm trying to figure out, if that would overload or if we can seamlessly make this transition, but thank you for looking at that.
And that's a good segue into chapter 30, if you could put that up. So one of the concerns that's been expressed, I should say, by a number of people, including Mr. Schulman, is the workload. I mean, we all know that. And so we went, as we saw last time, as Steve showed us, one of the big areas of workload for the Planning Commission is the capital budget. And so this section here, chapter 30, deals with the capital budget process. And so we thought we'd take a look at this and see if there's a way of potentially streamlining this to help reduce the workload a little bit. So let's walk through this. There's really only one section that's at issue here, but I want to show some other little nits I've made that we can take or leave. So Brian, is this the clean one? Do you have the marked
Could be
one?
the clean one, Tom. Let me just scroll through. No, maybe not.
No, okay, good. Okay, so we're back up.
Okay.
So let's go to the first change, because most of these changes are like changing Planning Commission to Planning and Zoning Commission. And every time I did it, I think we're going to have to pay for the printing in the paper, but what are you going to do? So that's 1, 2, 3, 30-1 through 5. Go to 6 then. That's the only changes in those sections. Then while I was at it, I figured I might as well do the gender changes that we approved in the past, but I thought, we don't have to do this, but if we're doing it, why not? You guys can decide.
I think that's what we decided, that going forward, we were going to try to be very consistent about that. So thank you for remembering.
Yeah, okay, good. All right, so let's go to 30-7, because this is the Planning Commission's role in the budget process. So looking at the budget process, talking to Lou and Fran and Steve and others, we're talking about what is the role of the Planning Commission in this? And it seems to us that if we could be more clear about what the role of the commission is. And I don't think this is in dispute. It's just, I just think idea here was to sort of lay it out, which is the role of the Planning and Zoning Commission shall be to ensure that the proposed capital budget projects program is consistent with the city's master plan for the fiscal development of the city. That's the POCD. That's just the language that's in the charter. So what this does is it prescribes what their role is. And to be blunt, sometimes the Planning Commission has gone beyond this, and maybe there are areas they should go beyond. But I want to be clear that this is intended to be a little bit of a limiting factor in the role of the Planning Commission in terms of the budget process. So open to suggestions on that, but we thought that by prescribing it this way, it's consistent with the role of the Planning Commission in terms of making sure that everything the city does is consistent with the master plan. I mean, they do it in the 8-24 reviews. They do it in looking at developments. So that's the intent here. And there's one more change that's not in this, but I wanted to just suggest, which is at the end of this language. It says, the Planning and Zoning Commission shall thereupon prepare a capital budget. What I'd like to change that to is, one sec, is to read, too many versions of this stupid thing.
Are you looking for that, Tom? Steve?
I know it's actually mine. It's actually another version I did. The last sentence I'd like to propose that it be changed to the Planning and Zoning Commission shall thereupon recommend the capital project program items which, in its judgment, the city should undertake during the ensuing fiscal year. What I'm doing there is taking away the requirement that the Planning and Zoning Commission come up with an actual budget. What they do is they'll come up with a recommendation. You know, they can do it in the form of a budget, but it's essentially the same thing. I think it's essentially the same thing in terms of recommendations. It doesn't prescribe what that form of that recommendation has to be. It could be in the form of a budget, but it's recommendations. So I propose that change. And
And Tom,
then,
can you stop right there for 1 second? Because it seems like Steve Kleppen has a comment that he'd like to make,
sure.
perhaps pertinent.
No, I'm good. Sorry.
Oh, you got your hand raised. Did you mean to raise your hand, Steve?
Oh, sorry. Yes, no. Ignore
Okay.
me.
I was like trying to be responsive. Okay, good. Then never mind. Steve doesn't.
And then just the corresponding change in 30-8, where it says the capital budget so thereupon. It's interesting, if you read the language of the whole section, it really doesn't really refer to a capital budget per se, but I think it should say the proposed capital budgets program shall thereupon be transmitted to the mayor. Steve, does that work as far as you know?
I believe so, yes.
Yeah. So, and then the rest of the changes, the other changes, let me just run through them and then we can go back and talk about it. 30-8, more forming planning and zoning, he, she, they. 30-9, planning and zoning. 30-10, I just, this is the adoption of the budget, no change there. 30-10-1. I sent this to Henry because it's interesting. I want to make sure this doesn't really affect what we're doing here, but you know, it's one of these things I'm looking at it. We got rid of the Norwalk Facilities Construction Commission. So that's unnecessary language. And I thought while we're doing it, get rid of that. But I also wanted Henry to take a look and see if there's anything else that he thought we should do. It's not essential to this exercise. I just point that out. And then moving down, I don't think there's any other change in this section other than the planning and zoning.
So Tom, I have one question for you. So other than the Planning Commission, is there any other commission or committee tasked with reviewing the capital budget?
You know, I can answer that. Steve, you want to answer that? You're probably a better. I mean, we do it through the planning committee. The finance committee also looks at it, but Steve, you want to talk about that?
And then I think it's just the BET and full council.
Right. And so does anybody else really try to tie it into the POCD other than, I mean, it seems like the committees do, but
Really, the only body that's charged with that, with this language or without, is the planning commission. I mean, when we look at it as a planning committee, we don't look at it in conjunction with the POCD, nor does the council, the finance committee, I don't think does.
so actually refocusing their attention to the POCD might actually be a good thing, just to focus them in on, is this with our master plan, rather than having them have a broad stroke about the whole capital budget.
They do that now. Any capital request that comes through has to get linked to a recommendation within the citywide plan. So that's been already coded. So all those specific tasks are already coded in there by finance. So any department's got to tag one of those when they submit their budget.
Thank you. That's helpful to understand.
So are there any questions on this section? Okay. Well, what we started out talking about was wanting to get more feedback from the public. And I like to propose, and I think the chair agrees, that we move this to public hearing with a couple changes to get that input. Doesn't mean we're going to approve it, but to see where people are. And again, it's also subject to review by the law department. And we'll still take comments, obviously, but I think it would help us all to get that input.
And I think our thinking was, as Tom and I were discussing this, was August is a pretty dead month. So we really wanted to bring it, we might be rushing it a little bit to bring it in July, but we're hopeful that we'll reach more of the public. Any
Yeah.
other comments or thoughts people want to share?
And by the way, it doesn't mean we're going to go to the council in July. It just means we'll have input. So if there's no further discussion, I'd like to move that we move the sections to public hearing. I'd like to propose that we tentatively change the membership to 9 regular and 3 alternate, with 6 being no more 6 in one party. Term limits, does anybody have a feel on that? I'm actually somewhat inclined to get rid of it altogether, but I don't know what the committee feels like.
I feel like 10, if you have 5 years or 5 terms or 10 years is a minimum as well, given the need for, some skills and some experience in this realm.
Well, that's a maximum. It's a maximum now, right?
Yeah.
I agree.
Well, right, exactly. It's a maximum, but I don't want to shorten it.
I do agree. Definitely don't short it, because like
No.
Mr. Yeoman did state, he stated that, someone like this, of this art definitely takes about 6 months to a year, to
Right.
be familiar with it. So that right there, kind of stood out as far as the numbers. He also did state, the truth as well. Like, with more bodies, there's more, information and more, people, but at the same time, meetings do tend to get, tedious, and, you might not get to where you really need to be.
Chance for more input too and insight.
Well,
I agree, term limits, and I think 10 is a good enough number.
okay,
Yeah.
so we'll leave that in. We don't need to put in the dates of the staggering, because we'll base that off the effective date, but for purposes of discussion, we'll go out with the January 1. On the chapter 79, I'd like to, given that we're paying for the printing, Brian, we're not going to put out sections we're not changing, and that includes the finance sections that don't need to be changed. So only changes related to this.
So Tom, you mean, let me just, I want to make sure, because obviously.
Well, actually,
Needlessly.
let me clarify that, because I didn't come out right. I had asked Henry to see if he has any comments. It's really on that section 10-1 and 10-2, because it requires certain reports be made. I don't know if those are being made, but that's not related to what we're doing here. And so I was offering Henry the opportunity to ask for changes if he wanted them. But I don't want that to slow us down. I don't think it's essential to this.
So chapter 79, the document that you emailed to me, has some changes, and there's one change that I have to discuss with you that I wasn't able to get in. But as it pertains to chapter 30, you only want the sections in chapter 30. It's not my, you only want the sections that have red line in them.
Yeah, because there are some in 30 that are not amended.
Yeah, I'm just trying to save money on the printing, Brian,
Yeah.
unless you tell me we got to put the whole thing in.
You don't have to put the whole thing in. We only have to do, so with 79, it looks like it's a new document, so we have to do that. But with chapter 30, the ones that have red line changes in them, we will insert only.
Okay, that's all I'm doing.
Great.
And the changes I just mentioned about the recommendations, first of all, we have here, and also the corresponding change to the next section. So anyway, I proposed a public hearing then. I move with those changes, go to public hearing.
Great. So I'll call the vote now. All in favor of moving this to public hearing for the month of July? Everybody has voted yes, so that's.
Just to clarify, we're moving section 30 and section 79.
We are. Both to public hearing.
Question.
So again, sorry, Kadeem, you go first.
No, I just want to make sure. So Lisa, we were trying to see that, basically saying that we could get to July, hoping that we can get the public participation from those for it to be moved closer to August or September.
So what we want to hear, what we're going to do is discuss, we're going to move chapter 30 capital projects program and chapter 79 planning and zoning commissions to public hearing in July, because we believe that there's going to be greater public available in July than in August.
Okay.
And we're also in the meantime hoping to get the legal opinion in, which we'll share with also with the public. Well, I don't know if we're going to share with the public at that time or not, whether that's the appropriate thing to do, but we'll work that through. But yes, right at this time, we really want to have public participation and hear what the public has to say about this work.
Okay.
So, Tom, I just want to make sure that I have this because I have all your other changes, but you were talking about in 30-7, you said that you wanted to switch the language, that you had another change in a different document, and it's the last sentence of 30-7. Are you talking about recommending?
I think you're muted, Tom.
Oh, yes, I am. I can give it to you now or separately.
Whatever's easier for you.
Let me just send it to you separately. So
That's fine.
All right, so what we have done is I believe that we voted to move this as a committee unanimously to a public hearing in July on these two chapters 30 and chapter 79. So great. Steve, thank you so much for joining us tonight. And thank you for your
I just want to clarify that we're really looking to get the public input to continue this discussion, not to vote and move this to the council.
I think we're just going to see whether or not we have all of our ducks in a row, and we'll decide as a committee at that time if we want to move it to council or not.
Yeah, David, it's I think, and this follows on what we said earlier and what Ms. Loricello said. We want input. We want to, I mean, I think it's really important. It's not a matter of rushing this. It's a matter of, normally we do in the process, you do this and you go right to the council, right? That's not necessarily our goal here. We figure that's the best way to get input.
I do agree.
I agree with that. And I think that's important in this, because I think that this for the purpose of this exercise, it's getting it right, not getting it done. And I think
David, just so you're aware, and for those of you who aren't aware, under the charter, when it's discussing ordinances, it says that you must have a public hearing. The public hearing can take place at the Ordinance Committee. The public hearing can actually take place at the Common Council. And it doesn't say that you can't have a public hearing and then go back and place it under old business if there's additional comments. So all that is required is that you have a public hearing at some point. Depending on the amount of changes, you might need a second public hearing if there's significant changes after the initial public hearing. But at a minimum, you need at least one. And it doesn't mandate that once you have that public hearing, you must vote and send it to Common Council. It just says you have to have one before an ordinance becomes law.
Yeah, thanks for the clarification, Brian.
Yep.
I think that's how we're going to move. All right, so the last order of business today is to discuss and vote on Chapter 37, Article 2, Sections 37.9 through 37.15. And once again, Mr. Livingston is doing all the heavy work. We all owe him a drink.
Muted again. Okay.
There we go.
So as you guys know, we passed this styrofoam ordinance 2 years ago.
I think you're the only one on this committee that
The only one.
here for that.
Okay, well, we did.
2 years ago.
Yeah. So, and we've had great success with it. It's been widely accepted in the city. And we've been very pleased with the way it's rolled out. There hasn't been many people opposed to it, quite frankly. But what we did find that in at least one instance of a grocery store who shall remain nameless, interpreted this differently than what we thought was the proper interpretation. And so let me just go back. Brian, if you can go to the top, I want to read the purpose clause. So it says the purpose of this article is to preserve and protect the environment in the city of Norwalk by prohibiting the sale, provision, or distribution of polystyrene products by food packagers and retail establishments. Retail establishments is very broad, includes any store essentially in the city of Norwalk. And so what happened was we had the one retailer come back to us and said, well, they can continue to sell styrofoam plates because their reading of the existing language was that the plates they sell were not being used in a restaurant or food service for serving or transporting food. Well, I think that was an overly technical reading of this. And while we've had some discussions with that establishment, it just seemed easier to fix this and avoid any confusion and just either now or down the road. So what this does is, it's only one section that's amended, is this definition of a polystyrene for food service product. And for those who haven't read it, the polystyrene is essentially styrofoam. It's defined later on, or above, I'm not sure where, but it says so we've changed this, there it is. Any product made in whole or in part of polystyrene, and it used to say, and used in the restaurant or food service industry for serving or transporting food. And there's the way I always read it was that it meant, and this is the argument, any product made in whole or in part of styrofoam and of the type used in this restaurant or food service industry. But rather than go through that and have the argument, we're just making it clear. I mean, it refers to any product made of polystyrene, and used for storing, serving, or transporting food or beverages. And that's really what we set out to say. And that's what we said in the purpose. So what we think is this is a relatively simple fix that avoids any confusion and fulfills the purpose of the ordinance.
Pretty straightforward. So I guess what we'd like to do now is vote to take this to public hearing also in the month of July. So will somebody make a motion to that?
I'll move it.
Back to Mr. Livingston. And then Brian, if you could take the screen off so I can count votes. I can't count votes.
And it's just what will be, if it goes there, it would just be the section that's highlighted right here, which is the top of 3710, which is the definition. And then this
Yeah.
right here, and that would be the only thing.
Those are the only changes. Great. So we're asking that this be taken to public hearing at our next meeting in July on the motion of Mr. Livingston. All in favor? Is that, yep, you're up there. Okay, thanks, Kadeem. That is a unanimous vote as well. So that is the full agenda, and I'll entertain a motion to adjourn.
Motion to adjourn.
It would be Mr. Roberts. Thank you. All in favor? Great. Well, thank you, everybody. We got a lot done in an hour and 15 minutes. Appreciate it all. All right.